So what do we do here?
We're going to need a motion to go into executive
Okay,
session.
so let me, does TV 79 know we're not going to start?
They do, and when you make the motion, I'll go in and confirm it.
Okay, so, on the record?
John.
Okay, thank you, Bonnie.
You're welcome.
Good evening, everybody. Tonight is Tuesday, June 25th, 2019. This is the Planning and Zoning Commission of Darien, Connecticut. It is 8:04, and we're in room 206 at Town Hall. Our first item is to go into an executive session. Can I get a motion to go into an executive session?
I'll motion to go into an executive
Can you second? All in favor? That's unanimous. So, TV 79 and Bonnie, we are off. Started back on the record
We are
after
on
an
the
executive session, and just in case you didn't catch us earlier, tonight's Tuesday, June 25th, 2019. This is Darien Planning and Zoning Commission agenda, and we're now in part of the general meeting agenda. Mr. Cunningham.
Possible vote to authorize town council to settle the case of Brookside Darien LLC versus Planning and Zoning Commission of the town of Darien.
So after we've had discussions with town council on this in executive session, the settlement documents have been in the planning and zoning office since what date, Jeremy?
June 10th.
Given that the public has had an opportunity to review those, I would like to entertain a motion to authorize town council to settle the case with Brookside Darien LLC versus Planning and Zoning Commission of the town of Darien.
I would like to make a motion to settle the case.
Could I get a second?
A second.
Yeah, all in favor? All against? All right, thank you. The next item, Kevin, we're going to skip.
Okay, so we're skipping number 3. The first item of the public hearing on the agenda is continuation of public hearing regarding proposed amendments to Darien zoning regulations, COZR 3-2019, put forth by Pemberton 16 LLC, proposal to add a new section 597 to the Darien zoning regulations to allow for the creation of housing for persons 55 years or older with the Leroy West Affordable Housing Overlay LW zone, where one member of at least 80% of the occupied units be 55 years or older. The full text of the proposed zoning regulation amendment is on file and available at the town's clerk's office and the planning and zoning office for inspection and online at www.darienct.gov/PZC.
Mr. Maslin, go ahead.
Good evening. Get organized here. Good evening, Mr. Chairman and members of the Commission. My name is Robert Maslin, and I represent Pemberton 16 LLC, which is the applicant here. I would like to submit, for the record, a couple of handouts that I'll describe in a second as I go through my outline here. There's a bit of a history to this, and I'm not going to rehash the whole thing, but what's brought us here this evening is this is the second of two fairly recent applications that effectively would change the age restriction that's on the property right now. The current age restriction is the one that would require, under the federal statute, which is adopted by state law, everyone in every unit to be age 62 or older. And we initially asked to remove the age restriction completely in a prior site plan amendment application. We're back. That application was withdrawn. There was no decision on it. Taking into consideration comments from the commission, staff, and town council, we filed another application that would add a section to the Leroy West regulations that would delineate or specify the age 55 restriction, and that would comply with the federal exception to the age restriction or the familial status and the state familial status and age discrimination exceptions. The reason for this is marketability. This project has been completed for over 2 years, and as a result of the age restriction, it has not been marketable for sale. The 5 affordable units sold right away at the affordable prices to qualified purchasers who are still in their units today. The other 11 have been very difficult. None of them have sold. Because this went into some financial difficulty, the current principals have decided some time ago now not to market these for sale because they just were not getting market rate interest in them from qualified people. Qualified meaning people who are over 62 years of age. The age 55 restriction is different in that it only requires one person to be over 55. And that would, we believe, and according to the brokers, I'm here with Diane Farrell of Houlihan Lawrence, who's one of the brokers that's been working on this for probably the last year plus. The marketing situation is something like this. It's on the market, it's marketed for sale. People come, they look, they find out about the age restriction, and they just don't want to pay what the current principals believe market rate prices are for those market units. On the leasing side, the problem is that they're being advertised for lease. The rentals are in line with other units in town. There aren't very many of them, but 1950 Post Road has a few, and we're in the same ballpark as those. Those are only one bedroom. The ones at Leroy West are 2-bedroom. So the rents are in line. The problem, though, is the brokers will get 2, maybe 3 calls a week based on the advertising, and during the course of that inquiry, whether it's in person or by phone, the prospective tenant learns about the age restriction and realizes they don't qualify because everybody in the unit has to be over 62. We believe, and this is backed up by the brokers' opinions, that by reducing the age restriction to 55, where 80% of the units have to have at least one person over 55, it opens up a larger market for rentals and most likely sales as well, and that would make these more marketable. I know you're probably wondering what the situation is right now. There are 3 units available for lease right now. One of them is under negotiation, but in the beginning of September, 2 other units will become vacant. So we'll have really a net of 4 vacancies in September out of 16. That's 25% of the units are vacant. The rents, the asks are $3,950 to $4,700, depending on which units they are. The rents that are actually being settled on are running between $3,700 and $4,300, again, which is in line with.
Can you say those numbers again? I'm sorry.
I'm sorry?
Can you say those numbers again? I didn't.
Sure.
I
The
didn't write them
asks are range between $3,750 and $4,700 per month.
Do you know how much it is per square foot?
I'm sorry?
Do you know how much it is per square foot? That's the unit of comparison that people use.
Because some of the prices are because of.
Yeah, it's hard to quantify it in terms of square feet
You're
because they're
talking
all
to
roughly the same.
You're talking to an appraiser. That's
I know that. I know.
careful.
I
I'll
know.
let you go. Sorry.
But some of them are corner units. They're worth more. Yeah, it's the location of the units,
That's not what I asked.
those sorts of
That's not what I
things.
asked.
Hold on, guys.
Hold on, hold on.
Sorry, John.
If anybody speaks, they have to get in front of the
Okay.
microphones.
I can have
Especially in this-
Diane come up and
Yes.
have
If-
this discussion if you'd like.
After the fact.
Or would you
Finish
rather
your
just
presentation.
finish, because I think I'm sort of trying to be on a roll here.
Yeah, go.
But those are the numbers. So another thing I found out through the research, and this goes to the handout that I just gave Jeremy, under the Fannie Mae and Freddie Mac guidelines for condominium unit mortgages, which are the mortgages that most likely the purchasers of the affordable units will get, or they'll at least apply for. They will have trouble because under the guidelines, there are two factors that you have to meet. One, if there are more than 50% of the units non-owner occupied, that's a problem, they're ineligible. The other is, and I didn't realize this until I started looking into it, if 2 or more units are owned by the same owner, they're ineligible. So that has a very negative effect on the marketability of at least the affordable units where people would apply for Fannie Mae, Freddie Mac mortgages.
Say that one more time.
Okay.
2 are owned by the same guy, condominium?
2 persons.
In this,
in
in
a-
what state?
Because it's 20
In
or
what
fewer
state?
units.
In what state?
Sorry?
In what state? New York or Connecticut?
It's a federal, it's,
Okay. I own 2 condos in the city.
okay. There's the first handout of the 2, I have highlighted language for you that describes both of these. In the first one, that's the Fannie Mae handout, and these I printed out today, they're very current. There's a definition section at the very end, the last 2 pages, that talks about this 2-unit ownership issue. And what it says is projects with 5 to 20 units, I'm sorry, it's more than 2, so it's 3 or more.
I kind of thought so, Bob.
Yeah, okay.
Careful.
Yeah, I'm trying to be accurate, and
What you missed.
when I looked at the actual
Sorry,
thing
John.
here, I
Can I,
got
can I
it.
just
So-
stop you there? I mean, you've
Doesn't
made a
matter.
very good case that the property is not viable,
Yes.
or you're trying to make a very good case that the property is not viable, based under the current age restrictions. I guess
Yes.
As-
my question is, why is that a planning and zoning commission question?
Because this was approved as
No, not,
Hold on.
was not approved
an 830G by a judge.
by a judge, okay.
And if you look at my
Not for-
last narrative, it says specifically, there's a couple of sentences in there by themselves that say, this is something the original applicant proposed, the commission denied it,
Yeah,
and the court eventually overruled the commission, but it's not something that you approved, required, or even considered before. And I don't think anybody considered it at the Superior Court level, because when there was a question raised about parking, the applicant and the judge said parking is not an issue because we meet the requirements in the regulations, 1.5 units.
of elderly.
Elderly, and that's where the elderly came in.
Okay, so now
But-
let's go to where where the regulations, and my question is going. You're
Okay.
proposing a 55 and under.
Yes.
Where would that fit in our regulations for parking?
In Leroy West, and there is a proposed section in the application that specifies 1.5.
Okay, so you would like the same
Same
parking
1.5.
density
Yes,
for 55 and older
yes,
as elderly?
yes. Now, let me just give you
Okay,
a
so
little
help
bit of
me.
support for that, all right?
Okay, now we do, I want to get to this parking issue, because this is what it's going to come
The-
down to, in my opinion.
Okay,
So I want to direct the discussion there, and you can add to
All right.
it. We have a document from an expert talking about the ITE standards. That's the Frederick B. Clark
Mm-hmm. Yep.
and Associates document that talks about the ITE standards, and that falls below the standards that he recommended in terms of parking density.
Correct. That memo is in the file. It came in during the prior public hearing, I think it was in March, Bob.
December, I think.
that was in the fall.
Yeah, December 28th, 2018 is
Right.
it's dated.
It might have
So,
been for the previous,
For the site plan, but that was with
but we're
no
going to make that
age
part of this
restriction.
record, is what you're saying?
correct, please.
Okay.
That was with no age restriction. We were asking.
No, I
To eliminate-
I get it, but
Right.
there's, again, this was proposed, I went back to the original record, 62 and older.
Mhm.
We all know, and our regs recognize, that there's less parking density required for 62 and older because
Yes.
of just the general activities in a community like of sorts.
Did you want the current section 904 part of this record?
Well, it should be, right?
Well, it's in there anyway, 'cause it's the
yeah,
regs.
It's the regs, so I guess what you're asking is 55 and older with no expert input to have the same parking density as an elderly. But clearly, there's going to be more activity, in my opinion, with a 55 and older because you have general population living within those apartments, so.
I looked at, I spoke with, who was our traffic guy? Doug DeVesta is an engineer, and I talked to a couple of traffic people I know, because I do this stuff all the time. The ITE talks about elderly housing and the parking requirement for elderly housing, but it doesn't say whether elderly housing is 55 and up or 62 and up. It just says elderly housing.
Okay. Well, our regs say 62 and
Your
up.
regs say 62,
So-
granted, but
And I don't have any expert, you talking to Doug DeVesta, I mean, if you want to keep this open and bring in
well, I
a
think we're
park-
at the end of the line on
Okay,
continuances.
well, you can continue it if you want to bring in a parking expert and talk about, what the appropriate density for 55 and older would be relative to a multifamily dwelling where we require 2.5 spaces. I mean, I go back to that original record, and it was very important
Yep.
that it was elderly housing because of the density of units on that small piece of property and the number of
I
parking
agree,
spaces,
it was-
okay?
that's
So now you're
what-
trying, your application is trying to expand the age groups. And I love the idea of 55 and older. I wish we did it at the senior active senior.
You didn't want to.
I understand that, but I think it's an interesting concept. I'm just very concerned that given the way that this property was constructed and the density, that there's not enough room to satisfy a younger population within that facility. And, you go to this parking memo, which is part of the record, and I want to give you an opportunity to go through it and have an expert maybe respond to it. But they're very concerned about taking away the loading zones and outside and creating more permanent parking spots outside of the garage. So
Well,
I'm just telling you, I have expert testimony saying that that is probably not going to work for that property due to safety reasons. So I think it might be in your interest to look at that and bring in an expert to counter that and tell us what the right density might be for a 55 and older community.
well, let me just
Do you get where I'm
mention,
going?
I understand, but let me just mention two things. During the prior application, we were asking to eliminate the age restriction entirely, and we were trying to add spaces in front of the garage, and we looked at reconfiguring the spaces inside the garage to come up with 2.5 per unit. Under the age 55, if you have 80% of the units, you wind up with 3 market units, and the net of that is add 3 spaces. Well, there's plenty of room in the front to add the 3 spaces.
You did the weighted average calculation, which I.
Well,
did.
you're adding,
Yeah.
you're convering
Assuming
3
that
units from 1.5 to 2.5, and that's,
your key
3.
assumption is that 55 and over is exactly, it has the same requirements.
has the same requirement.
As 62 and over.
Right.
I would counter that that's not the case, given that some of the people that live in those units can be under 55. So typically, you're gonna
Well,
have at
sure.
least 2 cars per household in some of these, at least.
But
Okay, so then you have a parking issue as you
Right.
liberalize the age requirements.
except that the standards don't distinguish between 55, which specifically allows people under 55, and 62.
Uh,
Right?
I
mean,
again,
that's-
I don't know. I'm gonna go back to our expert and say.
Okay.
If we leave this open and say, hey, I'd like you to comment on the differential between 55 and 62, because I think it's really important. Because again, 55 and older only requires 1 resident to be over 55. So you could have a household that has a 55-year-old, 45-year-old, and actually maybe even a child, right?
The way-
So those would be like 3,
18, yeah.
So
Except that the way.
it's a much different community than 62 and older. Everybody's got to be 62.
I understand that, but let me just take one step back and make the following point. when this first went through under 830G, the proposal was to apply the age 62 restriction the way it's written in the zoning regulations, which allows people under 62. The dilemma that we're in now
Wait,
is,
say that again. Go again?
under the current zoning regulations, age-restricted housing means housing where at least, I think it's the principal occupant or some terminology like that, must be over 62. Not everybody.
Is that in the Leroy West regs? Or
No,
the
that's in the,
definitions section
that's
210?
in the, I believe it's in the definitions.
That's
210.
important.
Oh, nine.
Definition of elderly?
Yes. Or senior housing or elderly housing.
Definition of elderly in the Darien zoning reg, section 210. Person 62 years of age or older.
Okay, is that elderly person or,
It says elderly.
okay, but what about the housing part? There's another definition somewhere in there about elderly housing specifically.
Dwelling unit for occupancy, but at least one person who is 62 years age of older. So one person.
What section is that?
It's page,
What's the definition?
definition of dwelling unit, senior, citizen, or elderly. A dwelling unit for occupancy by at least one person who is 62 years of age or older.
At least one.
At least
At
one.
least- At least one.
Means it can be more than one.
But that
But
is,
regardless.
that's what your 1.5 per unit is based on.
Yeah.
Yeah.
Right, but this is,
So we're asking basically to change the 62 to 55, but you still have at least one person over.
Again,
You know.
drastically different.
yeah, I mean, this is
But
not,
No,
that's,
who cares? My kids are in high school.
the dilemma that was created here is, and none of us in this room had anything to do with this. This was
Understood,
the original
understood.
applicant. And they proposed elderly the way it's written in the regulations,
Yeah.
between those two regulations.
But your client financed it.
Sorry?
Your client financed it, he knew it was going in.
He didn't know, no. Somebody sold him a bill of goods, I don't
Oh.
know. It turned out,
that's fine.
it turned
That's
out-
not our problem.
it's, I got it. And so it's really,
I'm-
what I think should be a consideration is a project that was intended as condominium units for sale,
That's not true either.
why not?
The zoning, the approval, and the application was for senior housing. It did not say rental or condominium. The Planning and Zoning Commission does not regulate whether you're gonna do a rental or whether you're gonna do a condominium. That was the developer's choice. Had nothing to do with us. The fact that they made it a condo, it's got nothing to do with us.
It was,
This is the Planning and Zoning Commission. It is not the commission that tells Dave Genovese to do rentals at Corbin Drive or to do condos at Corbin Drive. That's got nothing to do
you
with
don't
us.
ordinarily do that, but the application went in the
Or
way,
had a price.
the way it went in.
Did not go in like that. Read
Well,
it.
Well, the affordability plan has more calculations in it about purchase price than it does about rental.
that's.
Look
so
at the site
I
plan.
mean, that's,
Look at
Okay,
the site plan.
so we know what the intent was.
you know,
So again, I'm giving you
That's your
this
problem.
opportunity
All right.
on the parking front to bring in an expert if you
All right.
desire, to give an opinion on 55 and 62, because I think it just comes down to the parking. And
If
a
that's
55 and under community is desirable, I think, in this community.
Yeah.
At that property, it's troublesome, given the lack of parking
Yeah.
for the site.
I understand. And I also have in this revised narrative that I did, that was within the last week, talk about very specific location-related factors that,
Yeah, I read it, yeah.
you know, and it helps focus on this particular site, and that's why the proposed regulations are in the Leroy West regulations, not in the...
But
in the-
I'm looking at this from a legal perspective, and if we applied elderly parking for this proposal,
Are there any
we
other
are putting
issues?
ourselves out there.
Are there any other issues
That
that
you,
I would need to deal with, or the commission would have an issue with?
anybody else have other
If
issues?
if we come back with
Yeah,
the
because-
parking.
Come back with what?
Yeah.
What do you say?
Okay, so any other issues
Yes.
related, so if he keeps this open, do you guys have any other issues other than parking that you'd like to discuss at the next public hearing?
I do have other issues, but
We have a few people.
they're related to financials based upon his testimony about market rents and prices and what the developer thinks of market rent.
Okay, but that's
that's
viability,
financial.
and that's
That's
not
got
something,
nothing to do with this.
it, yeah, so.
So I don't really care what the
Okay.
broker says or what, there's no appraiser here, there's no licensed appraiser.
Okay, but that doesn't even matter based on.
It doesn't matter.
On our planning and zoning, so that's,
Judge approved.
I get your point, you can disagree, but that, we don't consider that.
I mean, I
Correct.
mentioned that a judge approved it to be this, right? There was a.
Yeah.
And so that's one, right? So we're going back and renegotiating something that we denied it, right? Then it went to a judge who said this is going to be approved
You're
this
gonna
way.
get.
I have, that's a problem for me. And also 55 parking and 62 parking, drastically different. Like, I mean, just basic. My kids are in high school. I assure you that if I'm living there at 55 and
You're not
Yeah.
You're not 55.
no,
yet.
I'm not,
Not
but
yet.
I'm just saying, there's 55,
I think
I
you
could be
say
married to someone who's
when-
55 right now.
When you are.
Like, this
Okay,
is,
we got it.
this is a
Okay,
different
that's the
parking
parking
situation,
issue.
which
We're
will
all
become a
talking at once,
disaster.
people.
Mr. Rand?
I have a question about what the role of the commission is in this specific instance. I'm not going to make, I don't know how to make the distinction between the original applicant and the subsequent applicants and all the rest of it. So I'll just refer to them all as the applicant, okay? The applicant got exactly what he bargained for. Now, we didn't give it to him, the judge gave it to him.
Understood.
And if the judge didn't give him everything he wanted, he had a choice to either withdraw the suit or to accept whatever terms the judge gave him. Having taken the latter course, I believe he got everything he bargained for. Now, whoever has succeeded to the interests of the original applicant in this property did so with their eyes wide open. They knew exactly what they were getting into. That goes for the bank, and that goes for whoever the current owners of Pemberton LLC are, or the intermediary people. I understand that the problem that they have is that the property's not viable financially.
Right.
Well, I mean,
That's not our problem. I don't believe that the Planning and Zoning Commission should involve itself in an application which is driven simply by the fact that the owners have done a bad deal for themselves.
I understand the point.
I mean, I don't think we should even consider this.
Well,
I agree.
we will discuss that in deliberations, but we have to consider it because it's before us, but it's a great point. Anybody else?
I'm with Jim.
I agree.
do we need an opinion from legal counsel if the applicant even has standing because they don't own the whole building? That's point one, and then
Okay,
point.
we'll let him answer.
They might be related.
Okay.
Then point two is, what the hell is point two?
Sorry about that. Point one, what's point one? Well, he's thinking about point.
No, point two is does it fall under our jurisdiction? Because the judge approved it and the town didn't, but did the town approve it by default because it's on our books?
No, but with the way Bob, I'll answer the second question first. The way Bob is presenting the application to the commission is a modification to the zoning regulations, to the Leroy West zoning regulations, which were approved by the judge.
Correct.
So at this point, there's no site plan on the table, no
Right.
special permit. He's asking to change the regulations which were approved by the judge along with the project.
And we were forced to adopt those regulations
Right.
into our.
You may recall that
Yeah.
Okay.
after the judge's decision came
You have
out,
to file something.
there was a question by the prior owner about, why didn't you change your map? He said,
Correct.
the judge approved your project, and so then
You have to change the map.
it became clear that the map change was also approved by the judge. Bob and
So would
his
this need
client.
to be approved by the judge?
Nope.
we
At this
have to-
point, any subsequent changes to the property, whether it's the building, the property itself, or the zoning regulations, come before this commission first.
Okay, now can you answer my first
The
question?
first question is, in my opinion, as long as the entity that Bob represents owns a unit, they have the right to come before the
A
commission.
single unit?
Not the majority?
Because isn't,
Te-
I mean, I know
Bob
nothing
can
about what the
supplement that.
condominium laws say at this thing, but I do know. what the
Condominium law says
I
the
did-
condominium association has the right to represent all of the unit owners
Okay.
in matters that affect more than one unit.
Are you
we-
representing the association?
Do we know who the president of the
That's
condominium
Pemberton
association
16.
is?
They're the original declarant, and it hasn't, they're functioning as an association.
Do we know who the president of the condominium
They're
association?
declarant, they're the declarant, which basically gives them the same rights as an
Okay,
association
well, we
would
don't,
have.
the condominium laws, the condominium bylaws are not part of the application, right? So
No.
I have no idea what's going on, so.
No.
Right,
I
Bob,
still don't know if you answered my question.
you submitted a letter from Douglas Poling, manager?
Right,
He is the manager of
Pemberton 16.
Pemberton 16.
correct,
Which is the applicant.
which is the
correct?
applicant and the declarant. And under basic zoning law, you don't have to own property to file a petition to modify the regs. You have to own property in order to apply for a site plan revision,
Yeah.
but not when it's strictly
Anybody can.
changing the regs or changing. the
Okay. So, were we
So-
clear on that?
I'm clear on your
Okay,
question about parking.
yeah.
The other thing I'm hearing is that there seems to be a sentiment that this shouldn't be here in the first place, or we shouldn't come back.
And I
And the
can't give
commission
you,
shouldn't.
I can't give you an answer there, I mean, because that's probably gonna be covered in deliberation, so, I mean, you can help me guide.
Yeah, well, the commission, there's other people who want
Yeah.
to speak, and we're still not done with the hearing.
Yeah.
So certainly Bob can certainly come back. I think, Bob, I was just reading through the record that I'd sent you an email a while ago saying technically the absolute deadline would be next week. The commission at this point has
Oh, you're
the possibility
July
of a
1st?
special meeting on July 1st, which is Monday,
Okay,
which is less than a week away.
I could do that if,
Sure.
We're gonna have a special meeting on this on Monday?
no, not on this. You have
We have
other,
another,
you have other matters that I'll be here for anyway. So it's parking,
I read that.
Yeah.
standing, I guess? Just so you'd have something on standing.
I'm sorry, so repeat.
Parking,
Yeah,
standing to make the application,
yeah.
right? And anything else that I've heard, I'll,
Yeah, I think standing has already been kind of affirmed, but,
oh, okay, all right.
so parking is.
I think that would
A response
more-
to,
The parking
expert-
question.
Yeah.
Yep,
What
okay,
is the appropriate, parking density for
Sure.
55 and older?
okay. And July 1st.
I know there's other people who'd like to speak on this, so if you'd like to speak on this matter, come on up. So, Mr. Gregory, we got your letter, very well thought out.
Thank you.
I don't want to debate whether or not 55, and I guess my question to you before you get started is, you find 55 and older communities throughout the states, throughout this state, so why wouldn't Darien want 55 and older housing?
Well, first of all, let me reintroduce myself.
Thank you, yeah. I don't know who-
Mark Gregory, 23 Georgian Lane, and for some of the less tenured members of the commission, I have a great deal of experience with Section 830G, both with the commission and, as town council knows, in litigation.
Are you a lawyer?
I am a lawyer, as a
Thank you.
matter of fact. And
Are you representing yourself right now?
I am.
Okay, thanks.
And the reason why I have an issue with this is not because it's 55, 58. or some other age. My issue is with what brought us here. And it's very important to know that, yes, this project was ultimately approved by Judge Cohn. Why did he approve it? How did he approve it? What was the process for approval? Okay, we went through the whole process before the commission. A record was developed, the commission made a decision. An appeal was taken from that decision. And what the court has to do in those circumstances is make what's known as a plenary review, a complete review. So it reviews all of the record that was made at the P&Z level. And so when he made his decision, Judge Cohn's a he, not a she, when he made his decision, he made it knowing the representations that were made by the applicant as to what this project was going to be. So had the project been undertaken and promised and presented in a different fashion, well, it may have, there may have been other comments, other evidence, other indications that would have weighed on the ultimate decision. So in effect, what the applicant is trying to do is take one little piece and ignore all of the rest. And I'm very, very troubled by that. I find this to be a very disingenuous exercise because it seems to me that the public has a very important interest in knowing that when they come to the commission and they make their presentations, it'll be taken into account. And that if someone comes, makes a presentation, makes promises and the like, and decisions are ultimately based on that, only to sometime later come back to the commission with changed circumstances, well, that smacks of bait and switch to me. And I find that very, very troubling. I'm troubled that the argument about familial status. When I read the petition, I didn't know anything about the Federal Fair Housing Act, so I researched it. And my research was very revealing when I dug in. And I quickly discovered that what the federal statute provides for is it makes it unlawful to refuse to rent or to sell or to otherwise discriminate against somebody on the basis of that person's race, color, religion, sex, familial status, or national origin. Okay, let me repeat that. Race, color, religion, sex, familial status, national origin.
Well, you're forgetting, though,
I'm not forgetting.
The 62 and older has been omitted.
No, that's not the petition here.
No, but I
The
wanna get
petition
to-
here talks about a potential violation of federal law. So let's look at the federal law.
And I've been there, and I'm
Yeah.
not an attorney, but there is 55 and older housing
Of course
throughout
there
the
is.
United States.
Of course there is.
Okay, so I'm missing your argument here.
What's missing here is age. Okay? The statute does not prohibit on the basis of age. Okay? That's important. So what did Mr. Maslin say? He said familial status. Well, to me, that's just a label that was trying to confuse the issue. Because familial status in this country, and I cited to it in my letter, means that you can't discriminate against someone because he or she has a minor living with that person. That's familial status. That has nothing to do here. So to cite familial status, doesn't advance the argument. All it does is reinforce the fact that I believe we're coming here on less than fair and honest bases. This idea about parking, okay? What did Mrs. Stefanoni say at the hearings before the commission? She said, we don't need as much housing or as much parking because of the proximity to town. And that evidence actually came up and was discussed in the Hoyt Street Commission proceedings and was discussed in the Hoyt Street litigation.
Let me stop you there. That's part of the record, right? Or that was part of the previous record. Can we put the Stefanoni?
Which aspect of the Hoyt Street
No,
record or
not
the
Hoyt
Leroy
Street.
record?
She said
She
Hoyt.
testified with respect to Leroy and West.
Yes, okay.
That we don't need more parking because of the proximity to town.
Yeah, so can we get that, we went through that whole file, I guess.
Do you want the transcript or the minutes?
I think the transcript would be appropriate.
Transcript, there
Leroy
were a
West.
number of hearings, just the one where she mentioned, that
Discussing the
transcript,
parking,
any or all transcripts where parking was discussed.
yes.
I think we should make a big, nice, fat file for this one.
Yeah.
Since our council said we didn't have one for the last one.
So what is market rate anyway? Market rate is what's a willing buyer willing to pay, what's a willing seller willing to sell. So the fact that the current owner isn't getting its desired price doesn't mean that these are not being able to be sold at market price. And I certainly, echo the comments that I heard as I was just sitting here. The fact of the matter is, these units are overpriced. And the fact of the matter is that the owner, the construction lender, did not do adequate due diligence before jumping into the project. These Fannie Mae restrictions, they certainly are current, but they're not new. These restrictions have been in place, and they should have been discovered during the due diligence. This commission does not exist as a vehicle for economic bailouts, for poor business decisions made by people who were well-positioned to do their research and to know better. And I believe that the private interests of the lender, of the owner, do not and should not override the important public interests here. So unless any of the commission members have more questions of me.
The other thing that you just said, you said market rate relative to sales. In your opinion, is that the same thread as rentals?
Yes,
There's
and,
no-
and I cannot speak to the hearings as to this project, but I can speak to, and I can tell you with absolute certainty, that during the Hoyt Street Commission hearings, when the commission asked Mrs. Stefanoni, are these going to be sold or are they going to be rented, she said, I have not yet decided.
And Mrs. Stefanoni was the same applicant for this project as the other project, the original one, it was a piece of grass.
The one and the same.
Okay, thank you.
Thanks. I don't know if you can take that statement and apply it to this, but it's,
Well, it's also still interesting.
When you look at the site plan, it says senior housing, it doesn't say permanent condos,
no,
it
no,
doesn't
no,
say
I get
we want
that.
condos,
That
it doesn't say we
statement
want
doesn't,
rentals.
it's sort of,
Good evening. Tom Birmingham, 63 Hoyt Street. Just be brief, just want to add voice to the record here. I mean, I think that, it's been established that this original application was well vetted by both the commission, the courts, and the public. And I think there was an expectation that what we're going to get in town was 62 and older housing, right? And that's a topic that has been discussed in other hearings, other projects, and in town broadly. So my sentiment is likewise with Mr. Gregory, that this seems like a bit of a bait and switch, which we may be open to in the future. I think it sets a dangerous precedent. I also have worked in banking for a while in the risk management function, and this is just bad underwriting. And what you do bad underwriting is you're either going to try and run a business that you're not a specialist in, or you sell it at the rate available. And I think I disagree fundamentally with the idea that this isn't saleable. I mean, I'm surprised that there are only 4 vacant units, right? Either purchased, well, to be, the max is going to be 4. Right? I think that was what the applicant said in the
It's a
commission.
lot of time between now and September. You can
Right,
rent next
but
weekend.
Your intent is to recover as much value as you can, but you also have reserves, and you can sell down, right? If you want to hold out, it's not the commission's role here to be an economic bailout, and there is a clearing rate for these. The affordable units themselves.
Prove that.
If we want this, if anybody, including the applicant, wants this to be an owner-occupied unit, you can make it all affordable. And not even that, you could just lower the prices. There's an appetite here, and I think that's well established. But I think it's important to note that we have approved plans for 62 and older buildings yet to be built in town. And I think that it's important to find out what those clearing rates are, either by rental or by sale. Or we'll have issues before. I mean, the broader public interest, where there's a desire to have that kind of housing stock, we need it. And I think this case proves that you got to know your market and you got to know those clearing rates, right? And so I think that it's very important to figure out, or maybe let this ride, because this is really an economic issue. It's a planning issue. There's no prohibition to reducing the rates or the prices, and find out what that is before some of these other builders or, you know, potential builders are looking at those units. And so I think that it's the public interest here to, you know, retain this, because that's what the public expected they were going to get, and court approved. There were 62 years or older or housing. Any other comments and any questions?
No, thank you, sir. Anybody else? All right, so we're gonna, do you have anything else, Mr. Miles?
I just wanted to make one comment on the statute. I have to wonder, why did Congress create exceptions under the age 62 and age 55 arrangements if it wasn't a violation otherwise? You have an exception because you want to leave an opportunity open. The second point is, that hasn't been mentioned, in the Connecticut statute, there is age specifically listed as one of the prohibited forms of discrimination. And the Connecticut statute adopts the federal age restriction exemptions as
I know in a
as
previous
their own.
application,
So-
we dealt with 62 and older is very clean, and that's why people gravitate towards it. I know 55 and older is maybe not so clean, if you will, a little more complicated, but
Sure, it's-
yeah, it
I-
exists though.
Yeah, it is, and, you know, you're required to do certain things and keep track of certain things.
Hold on.
So, yes,
Just before the, Jeremy, on the prior application to this, I asked you to put in the minutes from, I think it was the Settlers Trail application that Mr. Maslin represented, the developer.
Correct?
I think in the minutes, it said that I asked Bob to make that 55 and over, and he adamantly argued against it, and he wanted to keep it 62. Those are the minutes
You want those minutes in this
in
record?
this record, because
From the
it-
Settlers Trail public
I
hearing?
think it was the Settlers Trail public hearing.
Okay.
So,
Because-
Well, it might be the reg change.
It's either that one or David Geneviese's hearing over on
No.
Short Court, whatever it was.
Shortly.
Eastland.
East Lane.
That was an age restriction.
I know it wasn't, but it was supposed to be senior housing when they flipped it, but it wasn't in the resolution, that's why I don't care what the
So
resolution.
what did he say? Sorry.
I
So-
wanted it to be 55 and older, and Bob said his applicant wanted to be 62 and over for federal law.
Okay, so it was loosely referencing Settlers
It was
Trail.
in-
Do you
it
want
was in the
to,
minutes.
Penny, Ms. Glassmeyer's project? At one point, we
Or-
asked if you would like to go to 55 and older. I think that's what Mr. Albany's referencing.
Exactly right.
Do you want to have any?
that's a
comment?
different client with different objectives and a different
It doesn't
project
matter.
that's completely irrelevant here.
I just wanted it in the file, that's all.
All
I
right.
want those minutes in the
And
file.
if the purpose of it is to somehow ascribe those statements to my current client, I think that's completely inappropriate.
Okay.
Okay.
Sure, there were discussions, but one of the things I also discussed was the difference between the way the regulation is written and federal law.
Okay.
And that's why I insisted on having the 62 with everyone over 62, not just one member of
So
the
you
household.
recall arguing that you wanted 62?
I remember discussions about the 62, but keep in mind, the client
Different
had
projects,
specific
yeah.
objectives, one of which was only active seniors without the family members under the age. And that's why we went with 62, because under the 55, it defeated the purpose of having senior-only housing, meaning everybody over 62. Different objectives, different purpose.
That's okay. So
That-
check the other one.
I mean, it
on
has
East
nothing to
Lane
do with
too,
what we're
John.
talking about here.
Please, check the one on East Lane.
Okay. Anything else?
And I'd like to get a copy of it, whatever you're putting in,
It's the minutes.
That would be
so I
okay.
can address that. I mean,
Yeah, perfect.
we only have one hearing session left. I don't
Understood.
wanna-
Yeah, we'll get, if he finds anything, we'll get it to you.
All right, thank you.
So,
So,
Bob, you want to continue to Monday, a special meeting on, it's up to you.
Well, yes, I guess.
and what's the next meeting?
It would be
I
after
think
the
we're out of
deadline.
that.
We can't,
We're out of
we're out of time. So it's,
He can't extend.
he can not extend, he's already extended it from March to April to May,
Okay.
late June.
We've
The
run out of
latest he could go.
extensions. Okay.
It would be
Yeah, we're out of extensions, basically.
Monday. So you're saying?
Monday is still good?
Monday is still good.
Okay, all right. I'll get you something
So
tomorrow.
Bob wishes to continue it to a special meeting Monday, July 1st.
Okay, thank
I mean,
you.
it's kind of your request, and we're consenting.
Well, again, I mean, we can close it without any parking input. I mean, that's going to be.
Well, you've asked for information, and there's an opportunity to get it, so we'll
Okay.
take
I
advantage
mean,
of it.
I'm
Sure.
leaving it up to you if you'd like to
No,
close it.
I understand,
Okay.
I understand.
That'll be room 206, this
Okay.
room, Monday at 8 PM.
Okay.
Thank you. Next one, Ken.
Motion to close.
No, we're not closing.
Number 2 on the public hearing, continuation
Just
of
read the
public
title.
hearing regarding site plan application number 306, special permit, land filling, and regrading application number 459, the Mather Homestead Foundation, Inc., 19 Stephen Mather Road.
Okay, so we kept this open just for the,
Just for the ARB.
Architecture Review Board met. The letter which they issued is being passed around right now in terms of their review of that. You may recall the barn, and they had some concerns with the architecturals. In addition, when Doug DeVesta was here, the engineer on behalf of the applicant, he talked about making some minor changes to accommodate the fire marshal. So fire trucks could get in and go through the site a little easier. So they widened the driveway a little, cleared out the driveway a little more, and changed one turning radius. Doug had mentioned that those dimensions were shown on the revised plan. I don't think they were.
There was a discussion, Robert Maslin again for the applicant. There was a discussion between the engineer and Bob Bush, the fire marshal, over one of Bob's issues. And I had a conversation of working through the architect on sprinklers for the barn, and we're going to be fine on that. Doug DeVesta did the minor modifications to the site plan, as Jeremy mentioned, widen the opening at the street, and then widen one of the turning radius
On the driveway,
right in front of the barn. But they're almost imperceptible. I think it was a matter of, trimming back the lawn a little bit,
okay.
just to make a,
So minor
make the turning
changes.
radius.
You don't have those, though?
We have the changes which the
Okay.
commission has.
Okay.
I think what Fire Marshal Bush was looking for was the exact radiuses to be specifically called out on the plan, which I think, Bob, could be a condition of approval.
Yes.
It certainly could, yeah.
Okay,
I mean, in essence, it's a field adjustment,
understood.
So do you have a date of those revised plans, Bob?
June 13, 2019, revised driveway radii, it says.
June 13th plans.
And let me see if I have the original.
But those were the only two outstanding issues, was the Architecture Review Board, and you could see substantial changes have been made to the design, and the modifying of the driveway and access way for the fire marshal, which we believe have been handled by Mr. DeVesta, but could be conditioned with some exact details shown on revised plans.
Perfect.
If you look at the two, you can see barely perceptible
Okay.
differences, but
So we'll
they're
just
there.
put it as a condition
Yeah.
that those, desires by the fire marshal. on
Like
that.
fire marshal approval before zoning a permit or something like that.
Perfect. Any
All
other
right.
questions? Anybody out there?
Thank you.
Like to speak to it? Seeing none, can I get a motion to close this hearing?
Motion to close.
Okay, second.
Second.
All,
Sorry.
Albany, all in favor? Okay, great, thank
Sorry,
you. Go ahead, next.
Number 3, subdivision application number 624, flood damage prevention application number 108B, Chris Snow, 242 Old Kings Highway South. Proposal to re-subdivide the 0.56 acre subject property into 2 separate building lots with frontage on Old Kings Highway South. Proposal to repair and expand the footprint of the rear porch and the existing residence and perform related site development activities within a regulated area. The subject property is located on the north side of Old Kings Highway South at the northwest corner formed by its intersection with Glen Gorham Road, and it's shown on Assessor's Map number 41 as lot number 152 in the R1 third zone.
All right, Jeremy, you got an update on this?
Let me summarize this for the commission. I do not see the applicant in the room right now, but I did want to summarize the applicant. there's two parts to this application, a subdivision approval and a flood damage application for additions and alterations to the existing residence on Old Kings Highway South. The applicant first had to go to the Environmental Protection Commission for work near the Stony Brook. That was administratively approved. The next step was the Zoning Board of Appeals, because the applicant did not have sufficient size to subdivide his property. It's in the 1/3 acre zone, and he only has .562 acres, so he's short on acreage. So the public hearing was scheduled by the Zoning Board of Appeals. Mr. No did not show up to the public hearing, so the ZBA could not act on it. They, in essence, denied it because there was no evidence presented to them. But the ZBA did say at the time that your prior ZBA variance for the additions and alterations to your house are still in full force and effect, such that that aspect is okay, you don't need a variance for that aspect. So as Mr. No then proceeds to you tonight, as part of any application under section 1040 of the Darien zoning regulations, an applicant is required to notify neighbors within 100 feet of the subject property between 10 and 20 days prior to the public hearing and submit evidence to our department to prove that section 1040 has been complied with. Mr. Donite, staff member of Planning and Zoning Department, sent Mr. No a certified letter on June 3rd and followed up with an email on June 19th, both noting that you need to submit proof of mailing of notification to neighbors. As of right now, the public hearing, no proof of mailing has been submitted. In addition, no application fees have been submitted, and Mr. No is not present tonight to explain or present his application. So I think the commission can safely close the public hearing in light of the fact that the mailings weren't done, the application fee wasn't submitted, and the applicant is not present tonight. And the commission at a later date can deliberate in light of those facts.
Would we want to just continue it, give it another week or so, or?
Well, we have an issue with the mailings not being done. So if the commission were to continue it, you would have to continue it to a date to give him an opportunity to, again, notify the neighbors and submit the application fee and present an updated survey. So that would be ultimately up to the commission if you wanted to continue it to, say, July 16th.
Why don't we do that?
However, in doing so,
It's gonna make the million week.
it's going to be a problem in terms of timing.
We run out of time?
We're running Mr. No granted 2 extensions, and the 16th would not work from a timing perspective.
Can I ask a quick question though?
Well, that's true, so that's July 16th?
The 16th we need time to get the legal notice to the paper.
Yeah,
And we need to give him an opportunity time to get the mailings out.
sure.
So those mailings would have to go out, right? Now, and then there's a third issue, which is when the application was submitted was,
Wait a second, the question, you said that he didn't pay the application fee.
That's
Don't you have
correct.
to- When you put in the application, it says you owe $425, you need to add a check, right?
that's correct. And we wrote Mr. No a certified letter on March 14th,
So when he came and he dropped
knowing
off the.
you haven't dropped off a check,
So
you need
it's
to
not-
make out a check by March 26th, March to April to May.
Hold on,
But
just-
it's not even an application.
Yeah.
Right. He also does not have an updated survey showing the land he wishes to divide and did not receive a variance
Understood.
for,
I'm just, if there's no time, there's no time. If there's time, then I would propose that you just give them 3 more weeks.
But he hasn't.
But it's
I'm
not
just-
even- it's not even an application.
Can I,
Yeah, I don't agree.
if
He
he,
closed it.
Yeah,
It should never been opened.
perhaps there's another alternative. An application requires a number of things, one of which is a check.
that's correct.
He hasn't given you a check.
That's correct.
Therefore, we don't have an application.
Right. It's funny, Jim, we did talk to town council about this because this is obviously an unusual situation where the applicant not only didn't submit a check, He didn't notify the neighbors, and he's not here at the public hearing, and he didn't submit a survey showing what he wants to do, done by a licensed land survey. He drew it on, as you can see. So what council's advice was to open the hearing, put this information into the record, that they didn't comply, the applicant did not comply with
Okay.
the regs,
Yeah.
and
If you've gone through it
Yes.
legally, I'm happy.
Yeah,
with the
and so
advice.
I feel like the sense is to close the hearing, and we'll deliberate on it. It isn't, like, just from a legal perspective, it's important that we weigh in on this.
He can always re-apply.
I was going to say, there's no,
Do it like everyone else.
You can say that, but there's been appeals where
I get it.
it's gone against the town, so we just want to dot our i's and cross our t's. So, can I get a motion to close this hearing?
Motion to close.
Can I get a second?
Second.
All in favor? All right, thank you. We'll
Is this the
deliberate.
survey you're talking about, this is the handwritten part?
that's correct.
All right,
Item number 4 on the public hearing agenda, special permit application number 60Q, site plan, landfilling and excavation, regrading application number 121E, Country Club of Darien, 300 Mansfield Avenue. Proposal to relocate existing paddle ball court number 1, approximately 18 feet to the east, construct a 6th paddle court directly north of the 5 existing courts, associated lighting, decking, and retaining wall, and to perform related development activities. The 139-acre subject property is located on the east side of Mansfield Avenue, approximately 1,250 feet south of the intersection with Middlesex Road, and is shown as assessors map number 5 is lot number 40 in the R2 zone.
you out on this one? Okay. Mr. Cunningham's recusing himself on this one for
Should I
the,
stay here, or you want me to go?
why don't you sit on the,
You sit on the bench.
yeah, sit on the bench. Good evening, sir.
Good evening. Mr. Chairman, members of the commission, my name is Michael Sweeney. I'm a partner at the firm of Carmody, Torrance, Sandeck, and Hennessy in Stamford, and I'm pleased to be here this evening on behalf of the Country Club of Darien. As a point of departure, the certified mailings were sent in accordance with the regulations. A few days ago, the certificates were delivered to Mr. Ginsburg, who has them in the file. With me this evening are a few members of the board from the Country Club of Darien and members, Mr. Ron Kay, Dirk Dunlop, Brian Smith, and also Joe Phelan, who can also help answer any questions that you might have about the application. In our application, I tried to be thorough in going through the special permit standards. With your permission, I won't belabor that
No, please.
this evening. I'll try to hit the highlights and then answer any questions the best as I can. Some of the background to this is the club has been operating since 1957. It's a full facility club, well, of course, with golf that we all know, but also with tennis, a swimming pool, and also paddle courts. You were kind enough last year to approve another court, which was approved by this commission, which was added, and the application before you is for a 6th court. What the applicant has tried to do is to do it in a way that kept as far away from neighboring properties as possible, but also convenient where the existing courts are. In the application, you'll note that the level of the court will be lowered with a retaining wall of about 6 feet to further screen it, a fence on top, and also some plantings on top of it as well. There's also some natural screening there already, some very large trees. The building that blocks some of the properties, at least from Mansfield Avenue. The property is 139 acres. It's in the R2 zone. The application proposes no increase in membership. It's really just for the convenience of members. And
Adding capacity for paddle, basically.
That's true. The number of events, though, and tournaments and that sort of thing is not expected to increase.
Okay.
There's about 4 to 6 a year. There might be 40 or so folks who play. They can accommodate it with the 5 courts. However, it stretches out the period of time in order to get through the event. That will be condensed now.
You're doing the Nationals there again, right?
I think that we are. I think someone did tell me that. Yes.
Which was known as pretty
Yes.
successful event. From what
Yes,
I've heard, yeah.
they had done in the past, as I understand as well. So the application provides for the construction of a new court, identical to the ones that are there, right next to the existing courts. One court next to it's going to be shifted 18 feet. A deck's going to be constructed next to it, and then the new deck next. next door. 1,824 square feet is the size of it. I talked about the number of events over the course of a year, the decrease in the level when the excavation is done for the placement of the court to shield it more. I think you'll see on your topo, I have a topo map here, that I think the level is about 193 on the map. Getting back to the parking lot, I think it gets about 205. Neighboring properties maybe about 215. So as you know, probably just from your knowledge of the property, there's a pretty good slope from the properties at the back of Mansfield down to this area of the country club. The hours are not going to change. Right now, it's 9 a.m. to 10 p.m. However, it's rare that it's used with that frequency.
How about the months of the year? Do you know, does the season go through the summer now?
I believe it's all year, but it's primarily in the winter months.
I'm sorry, you're going to have to come up, sir, to just go on the record. Sorry about that. Yeah, we have, either one of you just introduce yourself, please.
I just consulted with my client. It's primarily a fall sport, but it is open to members all year long.
Yeah.
But just as from our knowledge of paddle courts, it's when the weather gets cool in the fall that you see the activity start to pick up among the membership.
Okay. Any change in the lighting technology?
The lighting is going to be as it's in your application. It meets your standards, all facing down, no zero spillage off-site. Our clients did engage with our friends and neighbors on Mansfield. There were some concerns that were expressed by a few of them. They were very kind to engage with us, and I think in your file you'll see some correspondence going back and forth. And to summarize it, I think the club tried to do the best they can to agree with almost everything that was asked for. I think there was one request that looked for some representation. There will never be any future changes made or construction made. And obviously, the club can't do that, but there were some requests that were made, and regardless of the application, they made them already. So, for example, there were a couple harsh lights in the parking lot. They've been changed to the softer lighting. There was some concern about noise, I think particularly at events where the speakers were surrounding and facing all different directions. So the speakers that were facing westerly toward Mansfield, they've been removed. So hopefully the sound is more going to the east now. There were a few other things that were done in trying to accommodate some of the requests made by our friends next door. And that's reflected in the correspondence, I think, that you have in the file.
Okay. Any other questions, guys? Jeremy, did we miss anything?
No, I think the only issue, which I'm sure Mike was going to get to next, is the issue of stormwater management. Jason Klein of Mike's office pulled together some information today. We ran it by Darren Ostafine of Public Works. As Mike said, the proposed new impervious surface is about 1,824 square feet, but one must keep in mind that it's on 139 acres, and the water from this will drain into the on-site ponds and water features on their property. So Mike is going to ask for a waiver under Section 888 due to the size of their property and the nature of the proposal.
Sir?
And forgive me, sorry.
If I can just, with regard to drainage and the ponds, there was an application 24 months ago about having to do with one of the ponds or a new
Correct.
pond, and it was
Approved.
It wasn't done. Well, it was approved, but it wasn't done, and the time was extended. Is that related to any? I mean,
No, it's unrelated to this application.
just out of curiosity, has that pond been, that whatever you applied for, has that been done?
Just commenced in February, will be done by the end of this year.
Okay, thank you.
Okay. Anybody else?
On the drainage issue, just to back up, rather than take my word for it, we had our engineer, Frateroli Company, prepare additional calculations submitted to the town engineer. There's stones underneath the deck for natural attenuation of water, the natural flow of the water, and he gave a pretty strident, strong opinion that there'll be no exacerbation of off-site runoff.
Got it. Do you have anything else?
No.
Anybody out in the audience like to speak to this application? I don't see any. Motion.
Motion to close.
Okay,
Second.
all in favor? Very good. We'll deliberate
What's up,
when.
Jason?
Next week,
Yeah. Okay, great. Thank you.
Forgive me, this will be next Monday.
Monday, yeah, deliberation.
Thank you very much.
Yeah, you're very welcome. Landfilling, excavation, regrading, application number 460, 17 Charles Street, LLC, 25 Schofield Farms. Proposal to regrade the property in association with the construction of a new single-family dwelling with new driveway, patio, swimming pool, stormwater management, and septic systems, and to perform related site development activities. The 2.68 plus or minus acre subject property is located on the north and east sides of Schofield Farms, approximately 225 feet west of its intersection with Allwood Road, and is shown on Assessor's Map number 8 as lot number 319 in the R2 zone. Jermaine, could you just kind of note what we're looking at on this one?
Sure. This is a property that's been vacant basically forever. There is I'll call it a detention pond area as you come around the curve for Schofield Farm Road, which is designated inland wetlands. And the applicant has been working on constructing a new house on this vacant lot for a few months now. The foundation is in, the work above the foundation is moving along, the new driveway's been cut in, there's a construction access driveway, I'll call it on the uphill side of the property. And they're here tonight to talk about regrading, which is more than 25 feet away from the house. So they're creating a few areas of flatter yard area and doing some things to accommodate some drainage and water flow. But basically, it's the areas of grading which are away from the house. So the house is approved, the house complies with the regulations, but we're talking tonight about the regrading in certain parts of this property.
Can I interrupt for a second? This afternoon, we emailed a letter from an applicant with an engineer's thing.
Not applicant, a
neighbor.
A neighbor. We do have a hard copy of that right here. We're going to send this around. This is from one of the neighbor's engineers, which just came in late today.
And I believe we got one from Mr. Schindler as well, a
Yes.
couple
That
days
was
ago.
yesterday. That one I printed out. I don't have time to print this one. This is from.
So this one just
someone-
came in at 4:30 today. This is from, the neighbor hired an engineer, and that's a copy of the letter which was emailed to the commission late
Did you
today.
see, did the applicant?
Mr. Kasudas, who's the applicant's engineer,
Yeah.
was forwarded that email. He's familiar with the issues that have been brought up by the neighbors, as well as this engineer's letter.
Perfect. Mr. Kasudas.
Jim Casides Engineering. I think Mr. Jeremy here addressed what the project is, but I'll give you a little more background. So we did get permits to construct the residence with the associated driveway and some regrading around the house. Construction started around the new year. Part of the challenge here is that we do have the pond and wetlands area down at the lower end of the property, which is along Schofield's Farm. The entire property basically drains into this pond, in addition to the neighboring properties as well. So we understand that we are on the hill, we are the lowest property just before the pond, so there is water flowing from adjacent properties. We don't, any of our water does not shed onto our neighbors.
All right, so you're the downhill side, if you will.
Correct.
Okay.
Just as the drawing is sitting, everything else is draining down into us.
Okay.
Can you just identify where the road and driveway are, because I can't.
This is the cul-de-sac of Schofield Farms, and this is the road that wraps around.
Yeah, and your
And our
driveway is the upper
driveway
right-hand
is
corner?
here, and loops around into the garage. And our construction access is on the other side. So we
Oh.
don't interfere so much with coming down all the way to the cul-de-sac and accessing through.
So I was out there today, I just want to orient myself. So the mud fence, or whatever you call that.
Silt
black-
fence.
Silt fence.
With the number written on it, the
Yeah.
number of the property written on it.
Yes.
That's the construction address, not the driveway.
That is correct.
Okay, thank you.
That is
Yeah,
correct.
that's up to you.
That is,
This is
right,
the
that
driveway
is
here.
at the far end here.
Well,
So, so the challenge was of climbing upgrade into the garage with set grade, limit of proposed max grades allowed. So the house was set at an elevation based on the allowable regrading possible into the driveway. So what that has done is created a need for the backyard, in order to create any usable backyard, to be flattened out to accommodate proposed pool, a small patio around the pool, some walkways, and somewhat of a flatter backyard before we get into the septic fields that are going to be raised based on field conditions, modeling and restricted layers. So the town engineering department has approved the activity in this area, around the house and the driveway. And the health department has approved the relocated septic fields with the septic tank closer to the house. And we are not encroaching within 50 feet of the wetlands to the pond, so we're not seeking for any wetland approvals.
So basically, you're looking for regrading of the driveway at all? Along the driveway? Are you looking for regrading?
It's not required from this commission to grant this, because we have already gotten permits for that.
Okay, so then you're just talking about the pool area, and which way am I oriented? That would be the south side of the house, correct?
Correct.
Jeremy?
The south side of the house and a little to the east of that, right
Yes,
near,
from
right in there,
basically
right?
from the back of the house, 25 feet is where the end of the pool is.
Okay.
Coming up to the retaining wall around, that grading is incidental to the septic fields.
Okay.
So coming back within the 50-foot setback and back over. So this area right in here is what?
Okay, so the net effect of that is you're bringing it down a few feet, as I see when you look at the Sheen's house and the Watson's house. Well, what side is that? That's
East.
the east side?
East.
So the net effect, as I look at the original grading and what is proposed, you're leveling the hill, and the net effect is a couple feet lower than it stands now? Is that the way to?
Well, it's this grade up in here at the max is going to be 8 feet lower than existing.
Yeah.
Say that again, how many, 8?
8 feet.
Okay.
And the material from here has been and will be utilized in these lower areas as we bring in the driveway, we're raising the grade, and like I said, the house is built on a slope, so there was material needed to build around the house and even under the house. So there's a good net, there's no net between cut and fill on this property. We haven't removed any material yet. Some of this work in here has been done, to be quite honest.
Near the house.
Near the house, yes.
Which
It had to
is
be scoped out,
allowed, yeah.
Which is allowed,
Yeah.
and also there's an access, the heavy equipment access path comes along the eastern property line, so there was a little additional work to create a path there, so that's why there's some activity.
That's temporary, though.
Yes. And
So do you know the square footage of the area that you wish to regrade basically? Do you have any estimate of how many square feet it might be, or Jeremy, maybe you can calculate that?
Does it include this septic field or the?
No,
culvert?
that's allowable. It's-
So it's outside the silt fence?
150.
Would you call it 80 by 80?
Yes.
That's 35.
80 by 80.
80 feet by 80, which is the area, I'll call it adjacent to the Sheen property line and extending towards, I'll call it parallel to the pool, and then across, it's the whole area between the septic system and the proposed pool.
Yeah, okay.
That's generally the area we're talking about.
Okay, and it's coming down on average by,
A few feet, and as Jim mentioned, at its max, it's a cut of 8 feet at one point, and then they're constructing a retaining wall.
The retaining wall is to help, on the far,
cut.
on the southern part, for the cut, so we're not cutting too close to the neighbors, or we're not extending the slope all the way to the base of the house. So
Right,
we're trying to get the water around the house, but we're trying not to cut that close to the property line.
okay.
The closest we've gotten with regrading, and it's shown on here, is 10 feet from the property line. So there's,
Where's that?
Right here, 172.
Up in there.
Elevation 172.
Right,
Right.
correct, 172.
And you
And
said the
that's-
distance from the 172 marker to the property line is 10 feet?
The retaining wall is 15 feet from the property line, and the grading starts at 10 feet.
Okay. Is that marked on here?
It's not labeled, no.
Because the space between the property line and the pool deck is 35 feet, right?
Yes.
And that's a retaining wall, which is 67 at the top and 64 on the bottom, so it's a 3-foot high wall.
Correct,
3-foot high retaining wall holding back the land.
yes. With the regrading on the upper side and the lower side.
Okay.
We're familiar with retaining walls.
Go ahead, sir.
Net, you know, fill in, fill out, I mean, it's not fill, we're regrading.
Approximate volumes?
Yeah, I mean, you said already that you're gonna use some of that to be around the house because you needed it,
Correct.
so you're gonna have to bring fill in on a net basis or take it out, or?
No, if anything, we will be removing fill. We'll try to use as much as we can so we don't have to haul out fill, but if we're not gonna bring in fill, no.
Okay.
No.
There were two letters.
There were
The
two-
McCord Engineering, you want to address that one first?
Sure.
So we just got
The
5 days ago.
McCord Engineering,
No, we got it over there.
we can blend the two together, because McCord Engineering actually touched upon the northeast corner of this property. So, item 1,
Actually, Jim.
Yes.
What we can do is, as you're describing and pointing, we can invite folks who want to see
Or
it to
turn
come
it,
around,
yeah.
stand right over there, or turn the easel, whatever. So if you're interested,
Should
you
I-
can see where Jim's pointing, or tilt this a little more.
I can put the easel here, I guess.
Oh, tilt it, yeah, yeah, perfect, perfect.
That way both the
A little
commission
too
and the
much,
public can see
yeah.
it.
Perfect. Yeah. Pull it out a little more.
Thank you.
No, this way, towards us.
There you go.
There you go, perfect.
Everybody can see?
Yep.
So just
So-
point to the regrading area, just for their
Okay.
benefit, just.
Right,
re-
so we are in front of this commission tonight for this area right in here. We are proposing to regrade this area to create a flatter property.
Any other regrading was authorized based on our zoning regs by the planning and zoning
That is
department.
correct. That is
They have
correct.
the right to regrade within 25 feet.
Correct.
When I say commission,
No,
planning
you're correct.
department, the department, yeah.
Correct. So, item number 1 mentioned the swale along the northern end of the driveway, leading into 2 8-inch pipes that direct water onto the proposed driveway and allow it to flow into the pond area, just as under natural conditions it used to happen. Under historical flows, the flow would throw right through here and into the pond. So we're trying to simulate a situation where when the water comes down, actually, it bypasses the driveway in the house, it comes down the swale into 2 8-inch culverts, pipes, and being redirected into the pond. There's been a concern raised that there's some pooling of water in this area. Again, I have to remind everyone that this property is under construction. In this upper area in here is very flat, as we can see from the contours. If there was some excavation in this area, a buildup of 3 or 4 inches of material at some point, and it is causing for this water to be ponding here, it's a construction site. It's to nobody's benefit for that water to stay there.
Okay, so that's a temporary situation that will be remedied.
Absolutely. And then the second thing, a lot of times this, as Jeremy has mentioned, this property has been vacant for decades. And there's trees and leaves and brush, and nobody really knows what was happening in that corner. Again, we're not claiming that there's nothing happening there and nothing has changed, but
Understood, okay.
it's to nobody's benefit to leave that.
But
If-
it's your
if we-
expert opinion that once the property is complete, there will not be pooling, significant pooling in that area?
That is correct.
Okay.
We
Is
will-
there a catch basin on that northern corner of that house as well?
There is a catch basin in the driveway.
Yeah, there you go.
Yes,
So within fairly close proximity of where that water is ponding?
that is correct.
ponding?
About 100, about
Yeah,
over 100 feet away.
Okay.
It's 30 yards. It's not close.
That catch basin is there to collect the runoff from the driveway.
I understood.
So the driveway, the upper section of the driveway and the residence will be directed into the storm drain system approved by Darren.
So to be clear, when you do the final regrading of the property, that northwest corner is going to, the intent is to allow it to drain alongside the culvert, alongside the north side of the driveway.
Correct.
And then into the culvert.
Correct.
Okay. Got it.
Yes.
Just real quick, was it dug out or was it filled in?
There was nothing done in that corner. We're trying to keep as many trees as possible along the property line here. So not much has happened in that corner. So it may be a natural flatter part of the watershed coming down. If
Well,
there
you
is
can
anything we can do.
You can also see from the pictures and by going out there, there's a little lip from just the construction, so.
Correct. It's not
probably
gonna
helped
stay
cause
there.
that.
Right, correct. So as much as we can remove that water, we will. If it's a natural pocket, there's not much we
Okay,
can do.
the other issue that they raised?
The other issue is focused in actually the area that we are looking at to regrade in here, why we are in front of you tonight. There's concern that, well, the neighbors are concerned that if we encroach any further into, closer to the property line, that we will be excavating the tree roots
Yep.
that are just on or 10 feet or so on the other side of the property line. We don't have an intention of doing that. There's no need for us to get any closer. We can propose to install a silt fence or a construction fence within.
Yeah, or markings that, that you won't.
So the
encroach
contractor
on.
doesn't encroach any
Correct.
further. We can set it at 8 feet from the property line, so give us a couple of feet to work. I don't think that's.
Yeah, please, if you'd like to add to it, please.
So my name's Peter Greenberg. I'm one of the owners and the builder.
Hold it, your last
Property.
name, sir?
Greenberg.
You got that?
So we've been working on the driveway. The driveway is finally almost in its correct position. It wasn't until a few days ago that we started digging the swale that's been approved to allow that water to drain. It has been done now. It is a little tighter than what was designed because we're trying to save all these trees on the side here. We've cut down way more than we thought, way more than the neighbors wanted, but all within as of right. So we're trying to see if we can get it to work without cutting any more. There may be one or two that have to come if we need to make it a little bit more gentle. But right now, if we have a heavy rain, the water's going to make it to that pipe. So that's speaking to this. So it literally wasn't until 2-3 days ago that we dug that. But it is dug now, and I expect that this wet pocket to dry out. We have started building the wall. I think the original approval allowed for a 70-foot wall. We've pretty much built 70 foot of wall.
70 linear feet, correct?
70 lineal feet, and it's between 3 and 4.5 feet high. Currently, some of it will be backfilled, so it won't be as high when it's done. We've been waiting to get our mason to work back there. He's been working on the stuff in the front because we're aware of the sensitivity of the trees in the back. But the first day on the job, we marked the property line. We put an orange snow fence on the property line, and we've disturbed as little as we needed to, or as much as we needed to. But we lost a couple of trees back here, unfortunately. When we opened up the whole site, wind caught a couple of trees and we lost them. But we're very well aware of what's going on here, and we will not encroach any further than we have to build that wall. So the only the additional disturbance is basically extending this wall a little bit, and then the soil will wrap around it. And the idea being, we really wanted to put in a pool, so instead of just maintaining a lawn here, now we have a pool with a lawn behind it.
Okay.
And that's it.
Anybody else, questions? Anybody else, questions here?
No.
Anybody in the audience like to speak to this application?
Can I just touch upon?
Oh, yeah,
one last thing?
sorry about that, sir.
There's another, the last issue that was brought up was concern, I should say, screening. So I understand that there's no exact species down here and what kind of plant it's going to be, but it's clear that all along the property lines, the limit of the borders, there's going to be proposed screening. to screen the neighbors from us and us from the neighbors.
And just to be clear, residential properties,
There's no requirement, regulations for any screening.
Okay, thank you.
People
this is
ask
for-
and they say yes.
Right, so one of the comments was not to build up, not to create a berm, not to create a dam behind the screening. When we install the plants, not to bring up the grade so we just
Understood.
stop the water from coming through. We're not gonna, that's not our intention, we're not gonna do that.
And that's
We have
something-
issues on other projects.
And
when
that's
others do
something
to us.
that our building department would, before you
Yeah,
sign
well,
off on the CO, you would
we
look
can-
to, right?
Correct. Because that gets to the whole issue of the grading. If you're going to, as Jim said, if you build up a berm, that's in essence regrading.
Yeah.
So you can certainly put a tree in the ground by digging a hole instead of berming it up.
Right.
And I think that's what
And
they're
if-
representing.
Right, and if we do have to do some kind of building up of ground in this area where it's wet to actually put evergreens in, we will space them and only mount around the root ball, not create a dam all across the property line.
And that's permitted by regulation, Jeremy?
That's correct.
Okay.
But just another point that this property is on a hill, so even if we were to dam it, the water's still coming towards us.
No, I get it.
There's no way that we could divert the water to any of the uphill neighbors.
Yeah, but the ones on the side then might be
Yeah.
impacted, so that's.
But the topography
I
made
get
it very
it.
difficult to do.
Yeah. Okay. Is that it, sir?
That is it? Any questions?
Sir, yeah. No, we're gonna go to public comment and we'll have you come back up if we
I'll
have.
leave this here for
Excuse me. My name is Gavin Watson. I live at 58 Horseshoe Road, just to east of this new property. My concern with this current phase of this project is geometry and slope failure. So the contour of the land is a steep slope. When they started the project 10 feet away from the property line, they dug a canyon 10 feet deep. So what you have now is a jagged cliff. Up on top are trees, a very large oak in particular that's quite a beautiful oak. And I warned everyone before even the trees were cut that do not impact that tree. Okay, so my problem with this section here with the retaining wall, they've already started work on it. In fact, they've almost finished it. And they've brought in some dirt. But it looks to me as if it's not high enough. They propose a 2-to-1. So I had to look that up. I'm not an engineer. But if we're 35 feet to the property line, 10 of which is now undisturbed, that leaves 25 feet and a cut down 10 feet. So it's a geometry problem, and this whole project is an engineering project in the extreme. I don't think you'd believe it unless you actually went there and saw it.
No, we've seen, I got some bigger ones.
I'm sure you
Okay, I
have.
can assure you that.
So my main concern, and echoing McCord Engineering, which we had take a look at this, is I'm really worried about slope failure. And what that means to me, as I saw in some of the engineering sites, is that to sustain a very steep slope and its new fill put in behind that retaining wall, it's not the original, the roots have all been cut out. So what's left to hold it together? If you plant trees, the trees are not rebar or pilings, they're just on the surface. And my concern is that the whole thing will collapse within 10 years, and then you have a big problem on your hands.
So we will ask the expert to address those concerns for you, okay?
Okay.
So you're concerned with the design of the retaining wall that's holding back the land that's adjacent to your property?
Yeah, I think it's woefully inadequate, and going to be a very steep slope. They do need the screening. It's kind of an engineering nightmare. So I hope it works, because if it doesn't, there's going to be a landslide there.
Right, we're working on other ones like that, too.
So that's basically what I was.
Yeah, I
gonna
mean,
say.
and I'm looking at the proposed grading, it goes from 172 to 164. On your property, it's a little less, 168 to behind, well, I'll have them.
They can
explain
work,
it,
yeah.
Okay.
So, my appeal to, this governing group is to keep a watch on it, make sure that it's engineeringly viable, because I don't want to be coming to the town hall or in a court of law if the whole land is a landslide and that big oak tree falls on their house.
Yeah, they wouldn't be happy with that either.
No.
I can assure you, the new homeowner.
Yeah,
they would say.
everybody's interest to make this work,
Okay,
given what it is today.
okay. Anybody else like to speak to this? Yes, certainly. Come on up.
Although it wasn't expected to. I'm Patricia Sheen, and I am.
I'm sorry, you have to get by the mic.
Oh, I'm
Yeah.
sorry.
And could you spell your last name, please?
Yes, it's Patricia Sheen, S-H-E-A-N.
Thank you.
Thanks.
At 64 Horseshoe Road. Thank you for your time. I've never done this before, so if you'll be patient with me,
No
as
worries.
Jeremy and Dave have been patient with me, trying to understand what's going on. And I think, as we said to Peter long ago, we wish you success. Our interest, of course, my interest is for the beneficial use of the property and for the safety of my family and our guests. That being said, we were on the side of that loss of trees. So we already know what happens when land is excavated and roots are cut because the wind came up before anything had been put in. The excavation itself, in my mind, and I think that others could dispute this because I have no expertise other than my personal experience, which was standing out there, the excavation caused such winds coming off of a cavern that trees, excuse me for barking, but we're right up here.
Sorry, you gotta
I
either
can't hear
pick.
you.
You hold that
You're
microphone
over
in
there
your
and the
hand.
microphone
You're
over
fine.
here.
You get to take it back from your hand.
So, may I turn?
It comes out of the thing.
Okay, so I'm right up here.
Yep.
This was all excavated. It was these trees that were affected right here. And one blew down. It was a few, actually, a few blew down. And Peter handled it. We really appreciate it. But it was evidence that when those roots are cut, substantial trees were falling. It
Were
fell
they your
across
trees
the-
or were they
No, they
the
were on
property,
the
applicant's
property.
trees? Okay. And they
That's a
fell
different
on
issue.
your
That's
property?
On the property, across two fences, into the pool, whatever. You know, of course, we're like everybody else, we're concerned about our dogs too, so.
They,
but
what,
that's
the
a
trees
little-
blew to your side or to the?
To our side of the property, so we're up here.
Okay.
And I'm thinking topographically too, but because the
Go up, though.
wind seemed to, and if I'm incorrect, please correct me, but the wind seemed to have been blowing up this way. And so it blew the trees into our property.
Yeah, the roots clearly compromised on those.
They were gone. I mean, there has been, I can't keep track of it. There is so much excavation of removal of dirt, of the land. I mean, it goes down, it keeps going. It keeps going and going and going. And this property that I have right here, there's a pool there. So a little bit of my concern is, as Gavin Watson and Alice have expressed, that, you know, we've had our pool. We bought the property like that. It's old. I don't know what it's gonna take for a shift, but that's my backyard.
Understood.
And the excavation is taking place within, I don't know, maybe 25 feet? And it's
Within
really close.
25 feet, you're saying?
Within,
Got it.
maybe even less than that.
Okay.
I certainly haven't measured. But I have no landscaping back there. And I can put some in, but Now, because we've got a pool fence, within that, it has limited the space that I can use. Now, water has been an issue. If maybe you've had the opportunity to go around Horseshoe Road, I know that Jeremy and Dave have, down Schofield. We're on a corner where we like the privacy. We really enjoyed the nature that we have left. We try to groom the property and take down the trees that present a problem. We try to screen out whatever is necessary, but other than that, we've really tried to maintain our trees. As you probably know, right across the street from us, across on Horseshoe, is the Carruthers property. That was over 2 acres that was basically clear cut. And we have felt the water come down our driveway and come through, even this, the trees that we have. I mean, it's coming our way, headed this way. So again, it's, when Gavin talks about pressure, we don't know what kind of geological pressure might be adding up. The Carruthers just bought the other property further east, so we know what's coming with that one too. So we are really looking at potential water issues. Our driveway is already starting to, I think they call it vatering. We're starting to crack now because of, what is, I guess, surface water? No.
Probably underground.
It's the underground water.
Yeah, and
So-
I mean, Jeremy, we don't, other than in wetlands or within wetland boundaries, we don't have any jurisdiction over trees, correct?
Correct. I think also what's interesting, and we've obviously talked a number of times about each of these projects, the new Carruthers house, which was across the street from Mrs. Sheen, as well as this property, will each have new drainage systems, but those are all not connected yet because the house gutters aren't done, and et cetera. So while there's temporary disturbance and temporary construction,
The regs require a net decrease or improvement in drainage on each one of these properties.
Could I have a point of clarification? Because that's something I don't understand. Is it surface water or groundwater or both?
It would be surface water.
Okay, because I'm talking about the groundwater.
Yeah, and we have no jurisdiction.
And you have
over
no,
that,
I understand that, because I'm getting an education, I am getting an education. But what I'm trying to point out is that it is the groundwater that is accumulating and topographically coming down through my property in spite of the number of trees that we've tried to maintain. It is coming down this way. And so when it gets to here,
Yeah, we'll talk to the engineer about it.
it's that, and so it's this type of whoops.
You're okay.
It's my dance. It's the screening there. For me, it's not just screening. It is also an issue of what happens to the rest of my property.
Okay.
And you could landfill it. I don't know how much compacting helps.
He's going to address the
screening-
sanctity of the
yeah.
slope, and I got a question for him, so if you're
Okay.
done, we can get somebody else. Anybody else want to speak to this? All right.
Thank you for your time.
So, guys, I guess if you could
Can I
talk.
ask,
Go ahead.
Jeremy, it's, Mrs. Sheen just said that 10 feet of land was taken out. Is that a true statement, or is that?
I don't know.
The road goes through there.
Right,
so
they created this temporary roadway to get, as Mr. Kasudas described earlier. So there might have been some temporary regrading in here. And I know they had to take out land and put in new fill for the septic system.
Okay.
Well,
Which has that?
Hold on, sorry, I can't do this.
Yeah, because obviously it's a site plan review application. We never saw this thing before, so if they took out 10 feet a third.
Right, but this was allowed by our regs, right?
So you take the hole and put
It's
it
right
in.
in that
So
area.
Peter or Jim would be able to explain that better than I could, because I have not been on site nearly as much as any of these folks have.
Okay.
Well, there were,
So answer Mr. Albani's question first, if you will.
Please.
Whether or not
What's your
about
question?
10 feet of fill came out of the area.
The answer
Oh,
is no.
Okay.
No more than 2 feet came out of that area. The only area we dug anywhere close to 10 feet was for the basement of the house.
Okay.
So the temporary access way that went in, again, just to kind of level it out and allow us to drive trucks in, maybe there was a 1 or 2 foot cut at most, a little bit of fill, but it's pretty much following the original grade. We did disturb slightly the roots of those couple trees, but what caused the problem was by opening up this big swath of land that had always been fully treed, it allowed the wind to come through. Actually, the biggest tree that fell was actually growing on a rock. I have pictures of it, where it had a taproot going in between 2 pieces of ledge. It was intrinsically weak. It fell, it did cause damage, we did make good on it. And I just wanted to go on record to say that between all of these neighbors, both for them and for us, we will be putting screening in. We retained a landscape designer that was actually recommended by one of the neighbors. He did the hardscape design. Once, if this gets approved, he will then go to the next step, which will be designing all the planting. And we intend to create privacy both for ourselves and for them in all the sensitive areas.
Okay. Can we talk about the sanctity of the slope and,
Jim can speak to it from an engineering point of view. From my point of view, we excavated only as far as we needed to get the house in. We needed to be able to drive around the house with machines. So we did excavate into a pretty steep slope. I did get called from the town a couple times that the neighbors had been concerned with all this rain we had this spring. So we had a really, really bad spring, and we had very little erosion.
Yep.
The wall has now been built. In the next couple days, it'll be backfilled, and I'm pretty confident we'll have no structural issues. Jim can speak to it from the engineering.
Okay, I'd like to hear from the engineer.
Okay. Is the structural integrity of the wall on these plans? Because I don't see. Sometimes you just have a cutout or something.
I think there's a detail on the second page.
That's what I was looking for.
All right.
it's, the reason why this wall was left to be 3 feet high is because it's a non-structural wall. It could be a boulder wall, it could be a masonry wall, but it's under 3 feet. It's not required to be engineered.
So there's a stone wall.
We laugh because we just been through this discussion on another application.
So it is, we've used a lot of concrete in it, and it is going to act.
Could you step closer to the microphone, please?
Okay.
Thank
So I'm
you.
just saying that we did build it with concrete on a gravel base. And based on the fact that all through this very heavy spring rain period, we didn't have any noticeable erosion. We actually did bring a landscape designer out to give his opinion, and we didn't see any trees threatened.
Okay.
The wall is now built. Once it's backfilled, everything will be even more stable.
So Jim, then just the slope of the, behind the Sheen's house and the Watson's house, talk to the,
The stabilization of the slope.
Well, that stabilization, also the run, so how many feet are we going down over what? So just talk about engineering standards and that sort of thing.
Can we correct the record because the wall's not on the plans? What am I missing?
Page 2. The wall along the back.
There's no detail. My apologies.
That's it, right?
Yeah, no detail of the wall.
No details.
Got it.
So we have no engineering details of the wall, that's only 3 feet and is not required, is what we're saying.
That is correct.
Okay. Got it.
So,
How far away is the septic area from the back lot line?
uh, 25 feet?
Okay, so back to my question. The slope.
So the slope. We're proposing a combination of, parts of the proposal is to construct a retaining wall with a 2-to-1 slope associated with it, and then the remainder of the slope is just gonna be a 2-to-1 slope, which means 2 horizontal, 1 vertical.
And that is
It's
within-
considered an engineered, stable slope to handle, to handle the stability of the land.
Okay, so basically it goes from 172 to 164
At the steepest.
at the steepest points.
Yes.
Okay.
Feet.
At the
I'm
most.
sorry?
Not at the steep, but
Like
at the most
it's an
excavation.
8-foot vertical over, looks to be about more than 20 horizontal.
Well, it's approximately 16 feet. If it's a 2-to-1
Yeah.
slope and we're cutting 8 feet,
Yeah.
we multiply the cut by
I
2.
understand, yeah.
So we're 16 to 20 feet in certain areas because we're not just taking a knife and cutting it right through.
That's as steep as it gets.
That's as steep as the ground will get, plus the planting plan shows that there will be plantings, and I know they're not anchors, but there's still any mature plantings over that area will stabilize that even further. But even if it's just lawn on a 2-to-1, it's
Yeah.
considered a stable slope.
Okay.
In addition to that, there's slope failures if you're trying to retain water behind the slope. We're not proposing to have a retaining wall with a lip which holds water and creates pressure. So everything that comes over land will continue to come over land. We also excavated test pits in the area for septic feasibility, which we didn't end up using in this case because the septic fields are further out. But there is a loam layer of 2 or 3 feet deep, and then there's a compacted sand and gravel layer below that, called glacial till. So groundwater cannot really flow through that. It's very compacted. So it's either going to stay in the loam layer, which is the upper layer, or very deep underneath the compacted layer. So that, again, when the water is up that shallow, it doesn't affect that 8-foot cut as much as if it was other materials, clay or silt.
Okay.
And the trees, yes, I have to agree with Peter that because there was an opening of that area, the trees that were left along the edge there are more susceptible to wind, and that is most likely what caused those trees to come down.
And they would have been compromised trees, not...
Correct, and then any excavation that happened was approximately 15 or 20 feet from the property line. Those trees may have been within 5 feet of that excavation, and the root mass would have been affected. We're talking about the neighboring trees that are 10 feet on the other side of the property line, which is 20 or so feet from any activity that we're proposing. So,
And well, it's if we were to approve this, one of the conditions of approval would be a silt fence so that you would not invade the...
that is correct.
Okay.
That would be a standard condition, yes.
Okay. Any other questions out in the audience, sir? Come on up. Yep.
I just have one last question about the wall. It doesn't appear to me, and maybe I'm wrong, there are no weep holes or drain holes for if water does come down there and pool, it'll just fill up like
Yeah.
groundwater, and it'll exert a lot of pressure and snap that wall right off.
So why don't you address that? I think I know the answer, but do you need weep holes in a 3-foot wall? It's not a structural wall, is it?
It's not a structural wall, correct, but I assume there will be an underdrain system behind the wall.
Yes, so what we'll do right now, it's sitting on a big heavy gravel bed, so that'll allow water through, but we will backfill we will put a pipe behind the wall and allow it to relieve the pressure to the sides. Rather than letting it come through the wall, we'll put a pipe embedded in stone dust, protected with filter fabric, and then backfill on top of it. So any water that does permeate through will be relieved to the sides.
Okay, and
that's not on the plans, though.
No, it's not on the plans. But
Okay,
it's-
so
again,
we
it's
can
a
put it
low-
as a
it's low wall,
condition.
so it doesn't need it, but we will do that.
okay. So Jeremy, if you could write that.
Yeah.
Let's see, how do you prove an as-built that it was done?
Well, in a case like this, the commission could certify that someone take pictures and present the photographs of that.
Wouldn't you see the end pipes?
It depends how it's designed.
We'll commit to prove it to the town
Okay.
and show it to
Okay.
inches.
Any other questions out there?
May I ask? I'll be quick.
Please.
This has to do with perhaps an area that is not within your purview, but I have a question. This is the septic field, which was moved. So it's now, will that be going upgrade?
It'll be pumped uphill.
Pumped
yes.
up?
Yes.
Okay.
So the tanks are down low, by gravity from the house, and then there'll be a pump chamber to bring
How
them up
many
into
feet?
About 100 feet,
100 feet, but vertically,
6 feet,
6 feet.
10 feet, I don't know, Jim, you might know. 10 feet.
We can.
This is pretty close to my property.
Yeah, well,
too
that,
now.
unfortunately, that's not part of this
Is
discussion.
if there's a failure of any kind.
Can you guys discuss this part offline?
Of course, I
'Cause-
just want to just throw it
Okay.
out there that we're below her property.
Okay.
So any failure would be on toward our property, toward the wetland, rather than toward your property.
Don't take it to the wetlands.
But anyway, that's the way it would go. Okay, but I'm sorry, that's not part of this application, so if you
I
could.
appreciate that.
Any other comments? All right, seeing none, could I get a motion to close this hearing? Could I get a second? Ms. Rand, all in favor? Great, thank you.
Thank you.
Okay, last one, Kevin.
Last one on the public hearing, landfill excavation and regrading application number 461. I'm gonna mess that up. Sheffield Toki, 15 Great Hill Road, proposed to construct a new circular driveway and associated with the development of a single-family residence currently under construction on the site and perform related certain activities. The .45 acre subject property is located on the west side of Great Hill Road, approximately 1,050 feet northeast of the intersection of Tokenique Road, shown on Census Map 36 is lot number 4 in the R1 half zone.
So, you want to get up?
Sure.
to speed
This
while
is a
we're
house
looking?
now under construction on Great Hill Road, and the proposal is to install a new circular driveway in front of the house, which will be cut a few feet lower. And then there's a little bit of grading, I'll call it on the southeast corner of the property. So there'll be the installation of a retaining wall in that corner. But basically, a lot of the regrading is to lower everything in front of the house to accommodate the circular driveway. I think you have in your packet a letter from the neighbor at 19 Great Hill in support of this project.
Okay.
Good evening, the commission. I'll try to be short. My name is Harry Roach. I'm with McCord Engineering, here representing the Topes.
Could you spell your last name?
Rocheville.
Thank you.
As Jeremy stated, the house, this raised patio and driveway are all in construction. The approved stormwater management system is installed but not connected. So we're here tonight to present for this horseshoe driveway in the front and this retaining wall right here in the southeast corner.
Can I just stop you 1 sec? Guys, we're not going to be deliberating tonight, so you don't have to stick around. We'll do it, I don't know when,
Maybe Monday.
maybe Monday, okay? Just so you don't have to stick around after. Yeah, no worries. Go ahead, sorry about that, sir.
No problem. But so as the house was getting under construction, the new homeowner started to notice that his front door would be fairly unusable with how the driveway comes into the side. So at that point, he approached us, asked us what we could do about it. We told him we'd have to go through special permit with you guys. You know, he was willing to go through the process. Great Hill Road is about 8% slope up, so we are pretty much on the verge of the 15% slope for the driveway, but coming off the 8% slope, it does seem pretty natural. I have a picture if you guys would like to see it.
No, it's,
Okay. We did add a driveway drain to compensate for the extra impervious surface added for the driveway. There will be 2 units extended onto the existing stormwater system, and there will be 0 increase in peak flow from the prior before the house was constructed
Yeah.
conditions.
and where are the drains on the new driveway?
The drain is right here, there's a high point right here, so you're practically capturing 80% of the driveway.
Okay,
And then over here, the other part of the proposal is to create a retaining wall that will be 3 feet tall at its tallest, and it is just to create, as you can see, there's not much yard space on this property. He just wanted some usable yard space. And as Jeremy stated, we do have a sign off from this owner that they have no issues with the wall. Wouldn't be diverting stormwater different than its existing conditions. And there is a row of arborvitaes along this property line that will remain.
Were the neighbors notified or something like this, Jim?
Yes, neighbors were notified by Harry's office, and all we got was 1 letter in support.
And does Public Works or anybody have to do about the curb cuts?
Public Works did send in a comment about the curb cuts, saying it is a little unusual to have so many curb cuts on a property, but it meets, I'll call it, it meets their standards. They don't have a standard specifically on that, but there's enough distance between them. What's interesting about this property is when you look at Great Hill Road, it is kind of in the far back of it, so very few people would come around the far back part of Great
Dead
Dane.
end, kind of, or no
Circular
outlets.
dead, yeah, no outlet.
Got it.
All right, any other questions? I don't see anybody in the audience to comment, so can I get a motion to close this public hearing?
Motion to close.
Second.
All in favor? Thank you. We have no further business, correct, sir?
No further business.
So can I get a motion to adjourn?
Motion to adjourn?
Second.
All in favor?
Yes.
Okay.
Thank you. Thank